Hello, and thank you everyone for joining this online session. My name is Anton Dutenko, and I'm a senior lecturer at the Faculty of Law and Justice at the University of New South Wales and a CBIL member. Today I have the pleasure of chairing the final and therefore naturally the most interesting panel at this conference. I begin today by acknowledging the traditional custodians of the land on which I, some of the speakers and viewers in Australia are currently located, and pay my respects to the elders, past and present. The title of our session is Regulatory Challenges and Cooperative Opportunities in the Digital Transformation. We will discuss some of the most cutting-edge issues in the ongoing global effort to promote the digital economic transformation. We'll tackle some existential challenges and the prospect of cooperative actions going forward. Our speakers come from different continents, and some have joined us at a very late or very early, depending on the perspective hour. Thank you very much for that. We are very grateful. In this session, we will tackle a wide range of issues, from the regulation of digital market power to the regulation of access to computing source code and encryption algorithms, to dispute resolution involving central bank digital currencies, and even AI governance. We will begin with 4 15-minute presentations, followed by Q&A. So, dear members of the audience, as you listen, please feel free to type your questions in the chat box, and our presenters will respond at the end of the session after all the presentations. Now I have the pleasure of introducing our first speaker, Deborah Healy, who will speak about digital market power, issues, and some solutions, hopefully more solutions than the issues. Deborah is a professor at UNSW Faculty of Law and Justice and a co-director of the CBIL Centre. Her research and teaching focus on competition law and policy in Australia, China and its Hong Kong Special Administrative Region, and the ASEAN nations. And she has written widely on them over a long period of time. She is a regular visitor to those jurisdictions to research and teach. And within the area of competition law, she is particularly interested in the role of government in the market, both in Australia and internationally, in merger regulation, competition in banking and finance, and digital economy widely. Deborah has undertaken substantial research in the development of anti-monopoly law in China against background of its political economy, and has written widely alone and with Chinese authors and material translated into Chinese. She has consulted with and completed research projects for UNCTAD, OECD, and ASEAN. And she's a non-government advisor to the International Competition Network and a member of the Law Council of Australia Competition Law Committee. Huge welcome to you, Deborah, and the floor is yours.
Thank you very much, Anton. Look, it's a pleasure to be here this afternoon to be part of this important conference. As a director of CBIL, I'm very grateful for the other participants making the time available, and also welcome all of the listeners online. What I want to talk about is in the context of the topic of this panel, regulatory challenges and cooperation in digital transformation. I wanted to talk about digital market power issues and some solutions in the context of what competition law can do to combat rising concentration across very many industries globally, but also issues arising from digital environments which exacerbate issues arising from other markets. And when you look at the competition law area and the control of market power, you're looking currently at issues which are being explored globally by most jurisdictions. In US, there's been a change in focus. The Chicago School was hands-off, and there's now been a more searching analysis of what's happening. In the EU, the legislature has responded to rise of digital market power and concentration by enacting specific legislation. And why is this all necessary? Well, The arguments are that large firms benefit from large investments in technology and small firms really can't make that sort of an investment. This means that large firms have become more productive and inventive, and in terms of digitisation, automation and market integration, this has been important. They favour large firms. And the argument is that there's less competition because there's been less stringent competition enforcement, and digital favours large companies. When you look at the superstars of digital, you know, you're looking at the Amazons, the Metas, the Googles, etc. They became superstars originally because of their superstar performance, but that has been reinforced by positive network effects and economies of scale and scope, and that means that markets have tipped. Consumers have benefited to a great extent, but the question really is, does the situation which the digital platforms find themselves in give them the incentive and ability to engage in conduct to hang on to their dominance and increase their dominance? And the role of data has been particularly important in that, and also the concentration which they have really deters market entry. So what can we do about it? Next slide, please. So digital platforms, which I've said can be good and bad, may possess seller and buyer power. And what can we do about it? Well, if you have a look at this slide, there's been worldwide reforms to increase the effectiveness of existing competition law, such as addressing evidentiary issues affecting mergers, redressing imbalance of market power. There's been direct market interventions like suggestions that there'll be divestiture to break up past mergers, direct regulation like the EU Digital Markets Act, which is highly complex. And why are these sorts of things necessary? Well, litigation against digital platforms is lengthy, costly, and by the time it finishes years later, practices have moved on. And they also only deal with a particular issue. And you know, by the time it's resolved 8 years later, everything's moved on. They're no longer wanting to do that, and you've got to start again. Data amassing has really assisted a tipping point in all of this. Traditional competition law tests don't really work. You know, we talk about small but significant price increases. A lot of these don't charge for their services. We talk about notification thresholds, but a lot of the companies that are acquired are far too small to fall within that analysis. So and also the measures like the Digital Markets Act, which has only just started and probably will work quite well, but they may have adverse effects, time and cost, increased uncertainty for business and dead weight loss. And some people say they're very heavy-handed. So when you're looking at this sort of legislation, you have to decide whether the benefits from increased competition, which they can engender, outweigh the costs. And at the moment, you know, we're looking at rules under the Digital Markets Act where you designate large entities as platform gatekeepers, and special rules apply to them. How that works, we don't know. I know that worldwide people are looking very carefully at the Digital Markets Act, including in Australia. But I can talk more about that if people want to hear more about it. But I will talk about another way of dealing with this sort of market power. And next slide, please. So the issue is, how can we address these issues other than by industry-specific laws? Now, I'm looking at collective bargaining by sellers or buyers, depending on who has the market power. Collective bargaining by the parties with lower bargaining power to give them more clout when they're dealing with the people with substantial market power. And the the issue is if the buyer has substantial market power, there are likely to be few options for sellers, particularly if sellers have perishable goods or they're dealing with essential platforms. And what happens when you allow collective bargaining is that the counterparty is a group rather than individual sellers. And there are other good things that can come of collective bargaining. It can reduce transaction costs compared to one-on-one negotiations, reduce asymmetries of information because information can be pooled, and that results in better informed decision-making for the counterparties. And it can enable more complete and efficient contracts to be negotiated efficiently because you're negotiating a contract for a whole group. So those are some of the pros. Next slide, please. But the downside of collective bargaining is that they are actually cartels. They're arrangements between competitors, and traditionally cartels have been prohibited absolutely in competition laws. You know, they may be a price fix or a primary boycott, which is an agreement not to deal. But the level of risk depends on these factors that are set out here. Also, the benefits from collective bargaining may not be achieved if the counterparty refuses to engage collectively. They may simply refuse to deal with the collective group, which they're entitled to do if in fact, because they are not a group collectively boycotting, they're engaging in their own behaviour. So you need to weigh up the adverse competition effects from collective bargaining and the public benefits to determine the net increase in welfare. Next slide, please. So there are a number of ways that collective bargaining can be engaged in, and it's been engaged in Australia for a long time. Various types of collective bargains are exempted under our competition law, the Competition and Consumer Act. There can be an authorisation where anti-competitive conduct, including cartel conduct, can be exempted if the resulting public benefit is likely to exceed associated public detriments, and public detriments are the lessening in competition and other detriments. If you apply for authorisation, which has been around in Australia for 50 years, you can get immunity for future conduct, which is specified by the applicants. There are no retrospective applications, and there's a very searching process. I've filled out all the way this all works here, and I can't take too much time, but the applicant has to explain why the conduct will result in a net public benefit and provide evidence. And our input is sought from other interested parties and considered carefully by the ACCC. Now, the ACCC can impose restrictions on the grant or on the time limit. And for example, in one recent Australian example, by smaller health funds negotiating with health fund providers, the condition on the authorisation was that the big health funds were not allowed to join. So there can be conditions imposed, and restrictions may be imposed. Sorry, it may be revoked for change of circumstances. It usually only works for 5 years, but there have been a lot of authorisations in relation to dealings with Google and Facebook about their use of news items from publishers. Now, another way you can do that is by notification, which I mention here, and that's a simpler process, and you can notify collective bargaining if in fact you have more than $3 million worth of transactions per annum with a particular supplier or acquirer. And that's been quite useful. There's also class exemptions, which are available for small business, for fuel retailers, and in the first 12 months of operation, that only came in 2021, there were 47 class exemptions granted by the ACCC, which allowed small groups of businesses. So The other thing we have in Australia to deal with these situations are mandatory and voluntary codes of conduct under Parts 7B of the Competition and Consumer Act. And we have had a lot of experience since the early 2000s with mandatory codes, such as our dairy code, under which farmers and processors who acquire their milk are forced to negotiate in good faith with specific contract terms and dispute resolution processes involved. There's also there are voluntary and mandatory codes. The news media bargaining code is particularly successful. It was established in 2021 for news providers to bargain with the major platforms, and Google and Meta have voluntary agreements with some publishers, but at least 30 agreements have been reached under this, which otherwise wouldn't have been reached. So my conclusions on this, next slide please, are that concentrated markets and entrenched market power raise significant problems for competition authorities. There are a range of possible approaches, and I suggest one is to redress the power imbalance by allowing collective bargaining, largely leaving the market to work so you're not imposing very strict regulations in a heavy-handed way, and codes of conduct can offer a light-handed alternative but complement collective bargaining by addressing the risk of refusal to negotiate, which I haven't really had an opportunity to deal with. Last slide. There's been a lot of work done in Australia on digital platforms. Currently there are and I've put the details here, but currently there are recommendations for codes of conduct to be adopted in relation to individual platforms which have particular market power in a specific area, and a code would be developed to apply only to them and give them certain obligations, rather than bringing in a holistic piece of legislation. That's the current plan. We're also having a review of national competition law and policy in Australia, and that is ongoing. At the moment, they are looking at merger review, and there are a number of suggestions about the way that our merger law might more effectively deal with mergers generally, and also in relation to digital platforms. But I think I'm out of time. Some of this material will be published in a forthcoming article in the European Competition Law Review, and if anyone's interested, I can give them the citation. And last slide, please. If anyone would like to contact me about any of these issues, there is my email address. So thank you very much for listening.
Thank you very much, Deborah. Perfect timing. That's what I like as the chair. Everyone's sticking to the time, my only job here. I think many of our viewers will appreciate the importance of the problem of market concentration, regardless of their area of expertise, and particular market concentration associated with digital platforms, considering that they are seemingly everywhere. There's massive proliferation of such platforms in areas that benefit from economies of scale, and in my area of finance, that would be anything from payments to various data aggregators that are facilitating the open banking framework. So thank you very much, Deborah. And now we move on to our second presentation. We will be talking about very important issue, the development of digital trade rules on access to source code. Our presenters will be Shailja Singh and Ms. Monica. Shailja is a lawyer and trade policy advisor with close to 14 years of experience in international economic law. She is a legal consultant, associate professor at the Center for WTO Studies, a think tank established by the Ministry of Commerce and Industry in India. She is part of the Government of India's trade negotiation, policy and dispute teams. And she has previously worked at the Advisory Center on WTO law and intergovernmental organization based in Geneva on secondment. And she has law degrees from the West Bengal National University of Juridical Sciences in Kolkata and the University of Cambridge. And Monica is working as legal consultant at the Center for WTO Studies as well. She provides legal and policy advice in a wide range of international economic law issues, such as digital trade and non-tariff barriers. She has a law degree from National Law University of Jodhpur and European Master in Law and Economics degree with specialization in economic analysis of markets, corporations, and regulators. Thank you very much, Shalja and Monica, for joining us. The floor is yours.
Thank you so much for that kind introduction. Greetings, everyone. Thanks, Sibel, for this opportunity. Delighted to be here today with my co-author and co-presenter, Monica. We will be talking about digital trade rules on source code access, and we would be covering it from an Asian Pacific perspective primarily. But what we would also be doing is looking at rules relating to ICT products that use cryptography, because during our research, we did find a fair bit of overlap between these two areas. So the way we intend to cover our presentation today is basically start with introducing the subject matter. What are we really talking about? These two key concepts. What are the main obligations in the select trade agreements that we have studied, primarily from the Asia Pacific region, and primarily the digital economy agreements that have arisen? What are the exceptions and regulatory gaps, if at all, that are present in the disciplines of these two areas? And that's about it as far as the outline is concerned. So over to you, Monica, and thanks you once again for this opportunity.
Thank you, Shalja, and thank you, Sibel, for the opportunity. We'll start with the next slide. Yes, as our paper states, decoding the digital trade rules on source code access, we first need to understand what the source code is. In very simple, crude terms, it is a set of instructions written by the programmer in a programming language, which are then communicated to the computer, where it is converted into object code, and then the task is performed. And before the source code, there's also a concept of algorithm, which is generally understood to mean a very simple set of tasks that would ultimately be performed by the computer program or the software. So again, the source code is just the human readable instructions written by the programmer. And there are open source code as well. But however, the proprietary source code, which is very important to businesses, they can be used to operate any operating system or search engine or the latest ChatGPT. Someone would have written a source code for that. The second slide explains the cryptography in ICT products. As my co-presenter stated, that there is a fair bit of overlap between the two concepts. Cryptography or encryption is called an art of creating secret writing. So it essentially provides a layer of protection so that only the person who has the encryption key or the access key can only access that information. That information can be a source code, or it can also be a communication. For example, on WhatsApp, the communications would be encrypted and only the receiver would be able to read those. So, however, in the trade agreements, we've seen it is limited only to the ICT products, which would, for example, be a semiconductor or a ATM credit card, where the information that is contained in the card is encrypted, or ATM machine, or for example, any other communication on through your phones or operating system on your phone. Those all would be ICT products where cryptography is used. The overlap is such that source code would be used to create the encryption code and the decryption code for the performance of cryptography. And also cryptography apart from protecting other information like communications, might also be used to protect the source code or the object code. So there is an overlap between the two, but then are not completely the same subject areas. The second slide, we discussed that how these source code and cryptography have been traditionally protected and what kind of digital trade rules are emerging now. So first, the patent law and the copyright law were looked at to gain the protection. However, apart from fulfilling a threshold criteria, the most important drawback for the protection is that it is limited in time. After a point, that information you seek to protect will fall into public domain. Therefore, the preferred mode of protection emerged as trade secret, where as long as the trade secret owner takes the reasonable steps to protect the information of the trade secret through non-disclosure agreements, through contractual requirements, then the state has, as per the TRIPS agreement, has to provide a framework to protect the trade secret. And here the protection is available as long as the trade secret owner is able to keep it secret. But that also due to some emerging trends where their government may require access to the source code for regulatory functions or for technology transfer functions or for other requirements. There was a push by businesses that the trade secret protection as envisaged under the TRIPS agreement is insufficient, and a new form of protection for the source code and cryptography has emerged through free trade agreements. And on the next slide, we will see these are some select agreements where there has been obligation to protect the source code on the government, and similarly obligation on the government or the state to protect the ICT products with cryptography. And generally, these obligations feature in the digital trade chapters, but interestingly for cryptography, particularly, for example, in the CPTPP agreement, it has featured under the tactical barriers trade chapter. So, but in the recent digital economy agreements, it has featured in the digital economy agreements, as you can see in the name. The next slide, we will explain that what exactly is the nature of the obligations. I will also refer to the relevant agreements that we have mentioned in the earlier slide. So firstly, for the source code, as I earlier said, it is a human readable set of instructions, but in the digital trade chapters of the free trade agreement, it is not defined. So there is an ambiguity on the exact scope of the source code. A restrictive reading could mean that it only means those set of instructions, nothing further and nothing earlier. However, some agreements like Korea-Singapore Digital Economy Agreement mentions the algorithm along with the source code, and also the UK agreement and Singapore agreement or digital economy agreement, it states that source code including the algorithm expressed in the source code. So you can see that some countries view that algorithm is part of the source code. So when there is not exact definition, a broad interpretation can mean that algorithm, which is the task which need to be performed ultimately as just a list of those tasks, would also be part of the source code. And then it can even be included that it might mean the computer program or the object code part of the information which is or the entire software as well. So that's one area of the nature of the obligation. The second would be what is the exact obligation? The primary obligation is that state is prohibited from asking access or to the source code or the requirement of transfer of the source code. It can be to the state or to any person of that state. So it is primarily based when a company is entering the market for the purpose of sale or distribution or manufacturing, it cannot be asked to share the source code as the requirement of that market access. In the case of cryptography in ICT products, again, it is limited only to the commercial ICT products, and financial instruments are excluded in all the agreements that we have looked at. There is one overlap with the source code obligation, that it is again a transfer or access of information cannot be required to the other person. That's the similar obligation. However, two additional kind of obligations are there. First is that state cannot mandate a particular kind of encryption method or cryptographic algorithm. Generally, it would mean that under the technical barriers to trade agreement and the chapters of the FTAs, state has the right to require technical regulation and conformity assessment process to test that technical regulation, except when the requirements of the TBT chapter are not fulfilled, which would be maybe unnecessary barrier to trade or legitimate public policy objective is not fulfilled. However, the state does have right to mandate the technical requirement for the goods in its country for the product safety requirement. However, this chapter restricts the state from doing so. The third kind of obligation is that the state cannot require a local partnership. So it would mean that you cannot have joint ventures or maybe R&D relationship or partnership or cooperation arrangements. These generally feature in investment part chapters or the investment treaties as a performance requirement. Interestingly, it features here in the digital trade chapter on ICT products. With these, and the ICT, it is another interesting aspect is that the New Zealand, can we go to the previous slide? Yes, the digital economy partnership agreement with New Zealand, Chile, Singapore, there the cryptography obligation is there. However, the obligation on source code isn't there. So it is interesting to see that how countries view one protection important than the other, depending on where their interest areas lie. Another important part is that many of these countries do not have any fear of forcible transfer of the source code or cryptographic information. However, they are still including these obligations as a gold standard of a digital chapter trade rules now. Now I will ask my co-presenter to take over and explain the exceptions part of the obligations.
Yeah, thanks a lot, Monica. So to just carry the discussion forward, as it would be expected, these protections and obligations that we talked about for source code protection or in relation to ICT products that use cryptography are not intended to be absolute in nature. There may be situations, there have been several situations where access to either the source code or the underlying encryption may be needed. And therefore, we thought it would be useful to see what kind of exceptions and derogations are present in the set of FTAs and the trade agreements that we have studied. So starting with the more horizontal exceptions that are present, we have the general exceptions. And if you look at the way they have been used in the FTAs, it's either by incorporating the GATT general exception or the GATS general exception or both. And this is, with respect to the applicability to the e-commerce chapter or the digital economy agreement as a whole. What is interesting over here is that except for CPTPP and USMCA, all the agreements that we studied have incorporated both GATT and GATS goods and services exceptions, while CPTPP and USMCA have only incorporated the services related exception that's there in GATS, which itself leads to some very interesting questions as to What happens if source code is embedded in a good? If the ICT products that use cryptography are classified as goods, do we have then recourse to only the GATS exception that's available? So there might be a little bit of a gap over there. If we look at the security exceptions, and perhaps we can move to the next slide because we have covered these 2-3 areas in a couple of slides or so. If we look at the security exceptions, then again, what we see is that there are 3 kinds of way in which they have been referred to in these agreements. We have in toto replication or reference to the WTO security exception. We have FTAs, for example, the Japan-Mongolia FTA, where the security exception language is exactly like the WTO exception, but it doesn't refer to the WTO provision. And then we have security exceptions, which are much, much more diluted. For instance, we see that in CPTPP, USMCA. And again, why does it become important for source code and cryptography related discussions is because we are talking about a situation when there may be a cybersecurity threat where access to source code may be needed. And then we have all these questions, especially when we are talking about the WTO security exception, whether it covers cybersecurity, if there is no emergency international relation, when it's emerging from a non-state actors, questions of attributions and so on. So in that sense, perhaps the diluted form that we see in CPTPP and USMCA might be more useful. And just a kind of trivia over here, if you saw the latest Mission Impossible movie, the whole script revolved around the so-called entities source code and how it was trying to take over the world. While we are not talking about extreme dystopian situations yet, but there are likely situations where for security reasons you might need access to source code. We have the government procurement exception. Let me not get into that very much in detail. If we can just go to the next slide. And the slide after that, perhaps I can specifically get into the specific exceptions that we see for these 2 areas. If we look at source code, what is very, very interesting is that, at the start, we had exceptions only for very 2, specific areas. Non-mass market software and software used for critical infrastructure. These were excluded from source code protection. However, over the years, this has evolved to give more regulatory and a judicial access, and we may need that kind of access. For instance, if there is a case like the Volkswagen case where there was a allegation and proven allegation of cheating on the pollution device that was installed in cars, or the Google case where you might need access to source code for finding out whether Google is indulging in anti-competitive practices and so on. So these kind of regulatory judicial access is envisaged in the newer generation of trade agreements that we have studied. The only additional point we would like to mention here is that the UK Singapore Digital Economy Agreement also has a specific exception for conformity assessment bodies, which we don't really see in other areas. If we move to ICT products that use cryptography, next slide, please. What we really see is that most of the exceptions are actually centered around, the next slide, please, are centered around parties' right to relating to access to networks that are owned or controlled by the government, so they don't enjoy the protection relating to cryptography in the FTA. There are exceptions for financial and banking related institutions and networks. But the UK FTA also takes it further and provides a more broader kind of access for regulatory purposes, not just limited to banking and financial sector. And if we can just move to the next slide, please, that deals with reflections, that deals with gaps. So overall, if you want to take a step back and look at the existing regulatory gaps in the FTAs, what we really see is that there are three kinds of perspectives that can be used. Next slide, please. If we look at it from the regulatory perspective, then yes, the agreements have moved forward and brought in aspects where more access may be provided for judicial purposes, for regulatory purposes, and so on. If we look at the security perspective, then we have a kind of standard now for having a more expanded form of security exceptions that may deal with some of these emerging challenges that we might find ourselves in. But if we look at the developmental perspective, and that's what we would just like to leave everybody with a thought today, what is actually not included as an exception is transfer of technology and use of technology for developmental purposes by the global south, the developing countries. And we can get into the debate about, the desirability of having transfer of technology and so on. But that's basically an area which we found was lacking and which perhaps requires further reflection as we go forward. So that's it. I think we have exceeded our time, but thank you so much for your indulgence.
Thank you very much, Shalja and Monica. What an exciting topic. I have to confess, I had not watched the most recent Mission Impossible, so I hadn't done my homework. Had I known it would be directly relevant, I would have done so. It's interesting to hear that finance and banking and finance is typically excluded from the scope of these agreements, but as a finance lawyer myself, I fully appreciate the challenge of striking the right balance between protecting on the one hand and disclosing on the other hand the source code and encryption keys and algorithms. And I think your presentation touches upon the very interesting issue of cybersecurity in this context, which is something we might discuss in the Q&A session. Thank you very much again. And next, the next presenter is Professor Heng Wan, who will be talking about a very hot topic today, which occupies the minds of finance lawyers around the world, central bank digital currencies, and in particular dealing with the disputes that might arise in this sector. Heng is a professor of law at Yong Pung Ho School of Law at Singapore Management University. He is an adjunct professor and a Siebel Fellow at UNSW Faculty of Law and Justice. He is a recipient of major grants and awards and has advised or spoken at events organized by international organizations and institutions such as APEC, the Bank for International Settlements, the Hague Conference on Private International Law, UNCITRAL, the ICC, IMF, World Bank, WTO, and ICSID. And of course, the private sector. He researches widely into tech and finance, including recently on generative AI. Heng, the floor is yours.
And thank you so much, Anton, for the kind introduction, and thank you for the invitation from the Siebel. It's my great pleasure to be here and to talk about the uncertainties of digital transformation and look into central bank digital currency. And if we look into the next slide, we'll see that actually we're facing, what I would talk about is digitization in general, and also actually CBDC as more specific issue. And I look into, how we deal with the potential issues like dispute settlement as a kind of perspective, understand how do we handle or embrace digital transformation. And we'll look into different dimensions of those kind of digital transformation in the following part. So maybe I can proceed on to the next slides. And when we look into the digital transformation, we think about generative AI, and also in finance, fintech. And here we look into our crucial issue here as a case study is about central bank digital currency, which is a digital version of the fiat currency, like the digital euro. And we see that's actually that ECB, European Central Bank, is exploring. The digital transformation involve many issues, ranging from data to cybersecurity. It also involves both domestic and international perspective. One of the issues we face for digital transformation is uncertainty. You can think about complexity as well, like cyber risk. You can think about environment. You can think about smart contracts. they may have lead to many issues, including disputes. And here we also see that there are many ways to deal with that. A useful way or series about adaptive governance, which help to promote interaction between different actors and networks to pursue a desirable state of social system. What I would like to talk today is about choosing central bank digital currency and including the disputes as an example to see that what are the landscape we'll face in digitization and how far away are we from addressing those issues. So firstly, maybe one question to start is that what are the disputes that may arise? So give one example, a smart contract. What happens if a glitch of a smart contract? You have made programming that you pay some money from country A to country B using central bank digital currency or digital currency, and then it's a glitch in that, or it's a cyber attack, whatever, and you cannot make the payment in time, and that may lead to disputes, violation of contracts, and so on and so forth. It also may involve issue like the state to state. If you have a digital transformation, like a digital infrastructure of cross-border digital currency arrangements, and what happens is a data leakage. So here's the issue that they are not really something we want to easily look into. So here let's look at the different types of governance. So we probably can think, okay, if we have those disputes, can we solve that under existing rules or existing arrangements? The answer is that probably not necessarily. If we look into Alta's ideal type of governance, one option that you look at the private contracts, so business reach contracts. But here we see a difference for digitization like CBDC. You heavily rely on infrastructure like cross-border platforms. So private contracts cannot address issue like mandatory law imposed by a country. Another option is interstate contracting. Here, like a treaty, bilateral treaty, you can think about the investment treaty or free trade agreements, as mentioned by the previous panelist. But here you have the issue is that whether in international financial law, it's not very common to see those new treaties for CBDC, and also they probably more rely on soft law instead of hard law. And here you have two options. One option that you have detailed treaty rules on digitization, which is maybe difficult because they're new and not necessarily has the same consensus, can reach consensus. Another option will be you agree on general agreements, say that we apply existing international law. But the problem is that we're not sure how international law, for example, apply to an issue with smart contracts because it's a technological glitch. A third option is like a principled multilateralism, like the World Trade Organization, where you have a petty body or the panel to adjudicate those cases. But even WTO, as we know, has faced difficulties in a petty body or the crisis of petty body. And also because of lack of detailed rules, it's hard to have those kind of multilateral adjudication in that regard, given the sensitivity of a currency issue. So let's look into the next slides. Since we already see that it's difficult, for existing governance modes to apply there, and it looks to be some distance from what we are facing and the tools we have. But one thing, if we look into the future, I think there are three dimensions of dispute settlements concerning digitization or central bank digital currency may be relevant. According to Mariel's work in 2011, there are at least three dimensions for understand what's the dimensions. If we're thinking of lawyer in an international organization or a law firm, how do we handle disputes arising from digitization? Not necessarily digital currency, can be other contexts of digital finance and so on and so forth. One is a social dimension, which talk about actors, who are the players, in this digitization. So obviously, and also we have a material dimension, which tells you what are the subject matter at dispute. And we also have a temporary dimension, which explains about when the issue arises and how long it will take to address the disputes. This dimension help to give a framework for us to, analyzing the landscape of digitization regarding dispute settlement and analyzing what are the key problems we may face. So let's start with social dimension. So we see that actually that digitalization may bring new changes. You obviously states, but here you see also a lot of reliance on intermediaries, because actually in digitalization like CBDC, you probably need commercial banks to help distribute the digital currency. You need also other service supplier like tech companies, provide tech solutions or security solutions. And also very important here for digitalization like CBDC, you heavily rely on platform or crucial infrastructure. So that means it's not really purely business one. Usually the platform involve a lot of inputs or even design by the central banks or other regulators. And here also international organizations like Bank for International Settlements and others will be an important player. So we see that in social dimensions that a lot of reliance on technology, a lot of reliance on the infrastructure that involves traditional players like states, international organizations, but also new players like tech companies, cybersecurity firms, and so on and so forth. For material dimension, I think that's important for us to look into what are the process, of the digitalization. You can think about CBDC from issuance of the CBDC to settlements, and even in the future, what do we see have an exit plan, for those kind of problem, or you want to burning those digital currencies. And here, two things is particularly important is about data. How do we handle potential data issues, data leakage, data integrity, and also how do you deal with technology? The problem we face for digital settlement about digitalization is that technology moves much faster than design of dispute settlement mechanisms. So these are complex, the challenge we are facing. And secondly, for material dimension, if you look into underlying issues, you have the issue about classification. For the complex digitalization issue like digital currency, how do you classify those issues? Are you classifying them as a legal issue? Or are you classifying as a financial sovereignty issue? Are you classifying as a national security issue, technology issue, and so on and so forth? That will affect which journey you will take on, or whether you can even start negotiation in certain platform like WTO or trade or investment and other. And secondly, risks. Digitalization also means not only opportunity, but also risks. How do you handle risks? These are very important one. And also more importantly, by not only identifying risks, but also how much you can tolerate the risks. Because you have a messy issue, if a new technology that comes first, you don't really have regulation. So you sometimes then you have the issue, how do you handle cyber risk, data risk, and other risk? So that's another issue we need to observe, and they may lead to disagreements or even disputes among different actors or different states. You can think about EU, for example, where they have have a EDP, privacy protection rules, and nowadays AI Act and others. They may have a different approach to other countries like US and other. So these are also a very important issue to look into if we look into the governance of digitization, particularly from material dimension. And thirdly, underlying issue is about what's the relationship between state and market. Here is an issue that if you have a state-led initiative like ECB has a digital euro or CBDC, what's the role of the state? Who bears the cost of infrastructure development? How that affect the governance of this financial system or even the civil society in terms of privacy and other? So these are some important issues we should look into. And finally, for temporary dimension, one issue is about willingness. What I mean willingness, it means a willingness to settle or not to settle disputes. So you may have, whether the issue will be addressed in time. It depends, for example, whether you have a need to make the digitalization operate. So if an urgent need to solve a glitch in a CBDC platform, for example, you may solve these disputes or these disagreements quickly because you need that to operate. But they will be very different if you look into landscape like international relations. If a geoeconomic dynamics, you have a standard setting, these are more challenging one, like soft law or principles or enforcement of those issues. Another issue we look into temporal dimension about timing or how long it takes to solve a dispute is about technology. Technology can solve some problems. You can think of smart contract, embed dispute settlement components, but technology also means challenges. What happens if the smart contract has been hacked or has been a glitch? And also, temporary dimension also depends on institutional or rural development. So depends on whether you have institutional arrangements that give you more confidence in digitization, or you have rules to give a kind of guardrail, or the landscape may like that institutional or rural development lag in hand because countries have different view, different stakeholders have different view, governance has not really addressed inclusive issue. So these will also affect the temporal dimension. To conclude, my final slides here, I would like to show that is that digitization means special features. That's we are now see breakthrough technologies like generative AI, CBDC as a transformative in terms of how we use the central bank money. That means new technology. That means that we don't necessarily know exactly what it will mean for us. And also the sovereignty issue, the data issue, because they generate data, and also the sovereignty issue, and also the multi-states involved, the heavy reliance on new infrastructure. So these are many issues that means digitalization is different from the landscape we have seen before. And if you're interested in those kind of work, you can scan the QR code and download my work in that regard. And secondly, if we look into dispute settlement, it's very important for the confidence of the rule develop, or the confidence of the digitalization. I think it's the elephant in the room that many of our practice or debate has really attached little attention to. It will be too late if we develop technology without doing that. So we have to think dispute settlement in advance at early stage. It's already not early stage. And finally, the existing transnational governance framework, like the bilateral treaties or multilateral trade agreements or contracts, may not necessarily suffice to address digitalization issue. So we should consider not only technical issue like expertise of adjudicators, it's a traditional and technical issue, but also broader issue like whether we're facing some issue are not necessarily legal one, and how can we use legal decision, for example, to find a solution to the dispute, or how can we use a dispute settlement mechanism that fulfill more than one function, because we may face non-legal issues like national security and other. So finally, the materials, temporal, and social dimensions are moving targets and deserve attention when we explore the future landscape of digitization, including ranging from generative AI to digital currency. Thank you.
Thank you so much, Heng. Perfect timing, which is wonderful. Just from my perspective, I would add that basically 5 years ago, CBDCs seemed like a gimmick to a lot of people, and today central banks have so much advanced in their thinking and even collaborating to develop cross-border settlement systems that are based on CBDCs, which come in different shapes and forms, from simple tests of cross-platform interoperability to more recently experiments to establish a single multi-currency CBDC platform. So what you have discussed, Heng, I think is going to be very important in the years forward as we develop these cross-border collaborations between central banks. So thank you so much, Heng, for this perspective. And last but not the least, the hero joining us at an unconscionable hour is Marta Soprana. Thank you so much. Who will be talking about AI governance in the context of digital economy agreements. Marta is a fellow in international political economy at the London School of Economics and Political Science, where she teaches courses on the political economy of trade. She has extensive experience working with international organizations, including FAO, ITC, UNCTAD, UN ASCAP, World Bank and WTO, and national governments on trade policy-related projects. Her research interests include digital trade, trade and services, law and technology, with a focus on the relationship between AI governance and international economic law. She holds a PhD cum laude from Bocconi University, a Master in International Law and Economics, a summa cum laude from the World Trade Institute in Bern, and an MA in International Relations from the University of Bologna. Thank you so much, Marta. Thank you for joining us. The floor is yours.
Thank you so much, and greetings from London. I am thrilled to be given the opportunity to present my research on digital economy agreements as a vehicle for AI governance. Next slide, please. This is a research that is supported by the LAC Research Impact and Support Fund that has allowed me to do some field work, which was essential for this research. This work is interdisciplinary in the sense that it combines sort of knowledge from both the field of international economic law and international political economy. And this is because it focuses on the understanding the interlinkages between AI governance and trade policy. And in particular, it focuses on trying to understand why Singapore has started to include in its most recent international bilateral trade agreements in the form of the DEPA, so the Digital Economy Partnership Agreement, and the Digital Economy Agreements, or DIAs, a provision that is specifically dedicated to artificial intelligence. Next slide, please. So this research starts first and foremost from the understanding of what exactly is the nexus between artificial intelligence and trade. That is because a lot has been written. There is a lot of information about sort of emerging technologies in general, about digital trade, but it's important to understand why artificial intelligence in particular is relevant for trade, why it differs from other types of emerging technologies and digital technologies. So one of the first aspects that needs to be considered is actually the technological impact on trade. What I mean by that is that artificial intelligence has changed and is projected to massively change the way that we produce, we sell, we distribute, we consume, and we trade goods and services across borders. And what is particular about artificial intelligence in comparison with other technologies, such as, for example, blockchain, that is essential, for example, for digital currencies that were described before by Professor Wang, is artificial intelligence is not really emerging, in the sense that this is actually a very old technology that dates back to the 1950s. But what has changed, what is emerging about AI, is that it is only in the last 10 years, more or less, even less, that we actually see the successful commercialization of AI applications. And this brings me to the second point, the fact that because now artificial intelligence can be successfully commercialized, and because AI goes way beyond the realm of trade, because it touches so many aspects of our life, governments have started to react to the opportunities and risks that are associated with the use of this technology, and are starting to adopt policies that are specific to this technology. So it's not just general data policies or other types of policies, for example, related to source codes that will affect all technologies. There are now policies and regulations that are specifically targeting only and exclusively artificial intelligence. And this means that because governments are doing so in a manner that is very different from one another, we can have a fragmentation of regulation across jurisdictions, and therefore potentially increase transaction cost for companies that are exporting and importing from different countries and in different countries. The third aspect of these AI trade nexus concerns the scope of application of international economic law. And that is because there is a big debate about whether existing multilateral trade agreements are actually able to cover and capture some of the most recent developments in digital technologies. And this is definitely the case for artificial intelligence. To what extent are services and products, in particular services, related to or provided through generative AI, are they covered by the existing general agreement on trading services, for example? But what is interesting is also that if on multilateral level there are doubts about the coverage of the agreements, preferential trade agreements are actually used as laboratories for emerging rules on digital trade. And this is where we see emergence, for example, in digital economy agreements of AI-specific provisions. Next slide, please. Now, we do have quite a bit of literature on trade regulation in the digital era that has been dedicated in general to emerging technologies, but only recently we have started to see some scholars that have started to look specifically at this nexus between artificial intelligence and international economic law. Some of them have done it from a more comprehensive perspective. Some have focused on certain issues, certain AI components. So there are some scholars, for example, that have looked at the issue of source code from an AI perspective, for example, and there are scholars that have looked into individual countries. So, for example, studies on what the European Union is doing with the proposed regulation on artificial intelligence, for example, and what the implications are for trade policy. What we also know is that there is quite a bit of literature on digital trade rules in preferential trade agreements, and in particular on the nature and scope and type of these provisions and depth, of course, as well as what could be the reasons behind the decision of some countries to actually negotiate digital trade rules in preferential trade agreements, and also the nature of these provisions. And this is where sort of my interest comes in and my work comes in, because not a lot of work has been done on the most recent type of preferential trade agreements, which is the DEPA, the Digital Economy Partnership Agreement, and the Digital Economy Agreements. So next slide. So what I'm trying to understand is these are the Digital Economy Partnership Agreement was actually the first agreement entirely dedicated to trade in the digital economy. And it was signed in 2020 between Singapore, Chile, and New Zealand. And this is a particular, besides the fact that it's the most unique type of agreement that we have so far, because it's very different from every other preceding preferential trade agreement signed in the world that deals with digital trade. What was particularly interesting to me is that this was the first time ever that artificial intelligence was specifically mentioned and explicitly mentioned in an international trade agreement. And it's the only, in that particular case, it's the only technology that was mentioned as separated from other technologies in that agreement. And what is interesting is that after that, Singapore has signed other agreements known as the Digital Economy Agreements, where again, they started including an AI specific provision. So I can see that there is some sort of like a potential for norm diffusion. And so what I'm trying to understand is, why did Singapore sign these agreements with this particular provision included? And also, I'm curious to understand, why is the language in that provision as it is? Because in particular, the language is very much best endeavor. And it basically says that the parties shall endeavor to promote the adoption of ethical and governance frameworks that support the trusted, safe, and responsible use of AI technologies. So this research very much looks into the following question. Next slide, please. It really tries to understand what factors influence a country's approach to the regulation of artificial intelligence at national and international level. And this is because I see that there are differences in the way that Singapore approached this subject to, for example, the way that the European approach AI regulation. The European Union doesn't necessarily have, not yet, signed bilateral trade agreements with specific provisions dedicated to artificial intelligence, but Singapore has. On the other hand, the European Union is proposing a domestic regulation with stringent rules on how to regulate AI, and Singapore doesn't. So what I'm trying to understand with this research is really understanding whether the AI policy that Singapore is pursuing at domestic level kind of like in a way influenced their approach to trade policy, and really trying to understand why Singapore has decided to include references to artificial intelligence in its newest digital economy agreements, and also what kind of lessons can be drawn from the Singapore experience in reconciling AI governance with trade policy. Next slide, please. So in my research so far, I've looked at different factors because the literature tells us that there could be economic, political, and also other non-commercial factors that that can influence a country's approach to negotiation and the content of their negotiations. So in this case, it's evident to me that the economy of Singapore, so the fact that it's a small economy that is very much reliant on open trade, and that is a country that is very much sort of as technologically advanced, has very much influenced the decision of Singapore to sort of try to combine sort of artificial intelligence governance and their trade policy. So in a way, sort of to try to use digital economy agreements as a way to build consensus, to try to find some sort of like interoperability or harmonized rules on on the approach to how to govern artificial intelligence. Another issue is geopolitics. So what kind of role does Singapore play in the world trading system? And I think that that is something also that has influenced this approach to trade policy and AI governance. Clearly also the level of technological progress. Singapore, to a certain extent, can be sort of the smart kid in the room in the sense of it can help sort of drive the conversation on artificial intelligence because it has been pursuing domestically an AI policy that very much looks into building talent, into building an economy that uses and develops artificial intelligence, especially to target some of the issues such as economic growth and some of the structural issues that the economy itself has. And another aspect that, of course, needs to be taken into consideration and may explain why Singapore also has resorted to sort of referring to artificial intelligence in their bilateral agreements is the status of the world trading system. Currently, there is a crisis in the system. The WTO is facing challenges both in negotiating multilateral trade rules as well as in the dispute settlement. So in a way, sort of, it is possible that Singapore has kind of like started to look into first building some sort of consensus at bilateral level on issues that are very sensitive, such as artificial intelligence, partly because this technology, as I said before, goes way beyond the realm of trade. So it touches also, it's a dual use technology. So it touches, for example, on military, it can use for military purposes as well. And therefore it can be essential for governments to try sort of to really find a good balance between how much they want to have free rein in regulating this technology, but at the same time also respecting whatever commitments they have made in other agreements. Next slide, please. Now, the reason why I think this research is relevant and matters is that, of course, it provides adds to the literature of the WTO and artificial intelligence. It adds to the debate on the use of preferential trade agreements as laboratories for new rules on digital trade regulation. But I think also from a policy-making perspective, this research can really help us understand what factors could be one has to consider when negotiating AI impactful trade rules. And also it can help us evaluate whether international trade agreements are or can be the most appropriate tool to use for setting global rules on AI governance. Thank you very much for your attention.
Thank you so much, Marta. Again, perfect timing. The regulation of AI, whether in trade or elsewhere, such an exciting topic in particular, and for some scary topic, considering the double use that you mentioned, potential for double use. in the military. So I guess the question is to what extent a dialogue, international dialogue, is feasible in this dimension. Speaking of dialogue, we have received a number of questions in the Q&A chat, so I will prioritize those as we move into this part of our session. I will go in the same order as the presenters deliver their presentations, starting with Deborah. And where I don't see a question in the Q&A, I'll take the opportunity to ask something I'm really interested in. Deborah, there's a question in the chat, so I'll start with you. Do you believe that special competition law regulation is required for digital platforms?
I'm in two minds about that. I am concerned about specific aspects of digital platforms and their competition. I think a lot of it can be dealt with under amended competition law, which would apply across the spectrum of business and industry. But I do think that some of these more specific codes which apply to particular digital platforms may be a way of more efficiently dealing with particular problems in relation to them without running the risk of over-regulating. I mean, the issue of over and under regulation in competition law is always an issue because over-regulation can kill innovation. You want people competing very aggressively and on their merits to actually stimulate the business environment. So I think that for a small country like Australia particularly, we don't want to do anything that's too sweeping at this stage. We may be observing what's happening in the EU in relation to its Digital Markets Act. We're certainly focusing on similar concepts of digital platform, digital gatekeepers, and we've observed that, but we have a much smaller market. So I think that by playing it the way we're currently planning it, amending our Act in some respects to make sure that it focuses on the dynamic environment, and then proposing codes for some of the practices, as well as in the digital platforms report in 2019, they also referred off issues relating to privacy to the Privacy Commissioner. They relayed off a lot of the issues which arose to more specific regulators, and I think that was quite sensible. So that's where I am at the moment, but in two more years I might have changed my mind. We'll have to see.
We need to reconvene in 2 years.
Yes.
And have this panel again. Deborah, thank you so much. Shalja and Monica, there's two-part question I see in the Q&A box. So maybe so it's actually two separate questions. You can choose, or you can maybe split those two. Who will answer which? So the first part of the questions: what are the security concerns related to source code and ICT products with cryptography? And the second one: what is the significance of technology transfer for developing countries, and what is its interface with source code cryptography? So they're separate questions. I'm not sure how they want to split it, or do you want to tackle one or the other, or ideally both?
Thank you for the questions. I will start with the interface of the source code and cryptography. As we discussed even in our presentation also, they are related and there is overlap, but they're not completely the same thing. So first, in the source code is applicable, it's not defined by whether it is applicable to a good or service. However, some agreements which refer only to the GATS part and digital chapter might view it as something only a service. On the other hand, the cryptography in ICT products, it relates to products, and most of the agreements have clarified that products mean goods and it excludes financial instruments. However, UK-Singapore Digital Economy Agreement does not have such clarification. So there, the product can, it would depend, the digital product, there's no settled definition right now. So whether it would mean only a physical object or even like a software, which is intangible product, would also be covered by that or not. It's something which is, I would say, lacking right now, the clarity on that. The other part is what kind of information is protected. There, the overlap, the source code seems to be more narrow and defined, the obligations on protection of source code. There, it says source code, however, in some cases includes algorithm also. So the source code there can be also for a source code for encryption code, or source code for decryption code, or source code to create a cryptographic algorithm which in itself decrypts or encrypts the information. So through source code, you can get information regarding the cryptography process which has been performed. On the cryptography information article, that the information protected is very wide, because it says any proprietary information, it says cryptography information or any other information. So that would, that's very wide, and any other information can just even include a plan to protect the just a normal paper or a discussion about it also, that how we would want to put in place a cryptographic system. And it can in fact include APIs, which are important to ensure interoperability and innovation, and so that other services compatible to the existing goods and services can be developed. So it can even include those APIs in the information related to cryptography. So yeah, there is overlap in the sense that source code can be for cryptography, and there can be cryptography of the source code, and there's some overlap in the goods and services part, but yeah, they are both separate concepts. I'll also briefly deal with the security concerns. For the cyber warfare and the threat to secure digital infrastructure is a huge issue right now. For example, in 2016, Bangladesh was attacked, the central bank was attacked, and around 1 billion USD was at stake, and they were able to protect it by the time 100 million around were already affected. So that can basically destabilize your entire economy. And similarly, there can be threats on electricity grid, or it might not essentially be a government infrastructure which is attacked. Even when large number of companies are attacked, that can also affect the entire economy of the country. So there is security concern in the sense that therefore a country would not want that a secure encryption system or a source code which is very susceptible to cyber attacks is used. So they would want basically a regulatory oversight of those, that sufficient level of technical standard and protection is there. Also at the same time, they're concerned that there might be a surveillance by other states or by the same state if there is not enough encryption protection, or if the information related to encryption of the source code is easily transferable or accessed. I would ask Shailja to come on with the other questions.
I have to step in as the chair and use my power, and I understand that you have, I'm sure, very interesting perspectives on this, but we really need to move on to the next presenters to make sure we can ask them the questions. If that is all right with you, Monica and Shailja, I'm sorry, but
I'm sorry for
we have to stick to the time. Heng, I don't see. Maybe I will see a question in the chat for you. You mentioned this cross-border dimension for development of CBDC, and now we live in the world where finance is used as a weapon, has been weaponized very recently, and even central banks, as history shows us, are not immune, are not safe, not to mention private parties. So now we have several projects that are promising to develop a single platform for multiple CBDCs. And it's very unlikely that financial superpowers are going to relinquish their hold on the financial system, which is supported by the exercise of extraterritorial jurisdiction. So what's the response? What can be the correct response to this challenge? Do the small ants in the jungle full of elephants have something to rely on in the dispute resolution system? Is there a solution to that?
Yeah, thank you very much, Anton. I think that's an excellent question. I really appreciate that. So I think that's they probably have two parts. One is that we see a likely fragmented international financial order. So the Ukraine crisis and also the geoeconomics means that it's hard to imagine all countries agree on those kind of financial order. And also you can think about sanctions. The sanction means different things for different players. And secondly is that how I think that secondly it's also about who you are looking at. For big players, yes, definitely is challenging in that regard to agree with each other. For smaller economies, mid powers, they probably need a public good, because in the digitalization, you want some infrastructure, everyone will be connected. That'll be good. I think that's Monica also mentioned that for digital trade, where Singapore, as one example, want to see rule-based, predictability in that regard. So you see different players have different interests, And certainly how about dispute settlement? For dispute settlement, I think that's an issue. That means more disputes may arise because you have different systems. They're not necessarily interoperable with each other. Compliance may lead you to different directions. You comply with one doesn't necessarily mean they comply with two. And secondly, is that if the dispute happens, how do we solve that? It's more increasingly difficult. We have to think that in advance. So because you rely on infrastructure, you rely on central bank, cross-border central bank digital CBDC platform, how do you handle that? Yeah, I think that still deserve more attention by every actors. Thank you.
Thank you so much, Heng. And finally, Marta, you have the choice. Yeah, I see two questions in the Q&A chat. You can choose whichever you prefer, but they are related. The first one is, how do digital economy agreements that you mentioned help address regulatory challenges in the digital era? It's a general question. And the second one is more specific. In what ways can digital economy agreements provide a framework for addressing AI governance issues? So that's probably more specific. I'll leave it to you which one you would pick.
Yes, I can kind of combine them because they both rest on sort of one particular aspect of the digital economy agreement that makes them so different from the others, which is this modular approach. Because contrary to other preferential trade agreements that had been signed before, under digital economy agreements, the issues are addressed under different modules, and the different modules can have different depth in the way they address an issue. So in particular, with new frontier issues such as artificial intelligence, you can use digital economy agreements to, through a soft approach. So while for issues such as, for example, source code on others, you can have more stringent rules, even though maybe couched with exceptions. In the case of AI, you can use digital economy agreements to start creating some sort of language that is for the moment just based on best endeavors, cooperation, and exchange of best practices, and maybe use those to start building a little bit the consensus on a more sort of, if you allow me, on a more shallow level at the moment, but also in a manner that will allow you to see whether the technology progresses in such a way that then it requires way more stringent rules. So I think from that perspective, digital economy agreement, from the way that they're framed, could be at least the first step to start really addressing AI governance at a moment where we really don't know yet what the true risks of this technology are and how really to regulate it. At least we can say we need to regulate it, and we can write it in the digital economy agreements. But the way to actually do it, we can postpone it in a way at a later date. And this approach could be maybe multilateralized, maybe.
Well, thank you so much. Thank you so much, Marta. Thank you so much, everyone, for your presentations and for your very insightful responses. To conclude the session, very, very briefly, not more than 30 seconds each, I would ask you to raise a question for the audience or propose a call for action. So let's turn the tables for a bit and just in the same order, Deborah, Monica, Shalja, Heng, and then Marta. Over to you, just 30 seconds. Do you have a question for the audience to think about, or do you have a call to action?
I have a question for the audience to think about, and I think it's an important one, which relates to how do we balance the benefits that consumers and others receive from digital platforms with the need to ensure a competitive environment. And this is the critical issue that's being addressed by competition authorities and others worldwide. And I'd leave with you that question, and also the question of does the behaviour of digital platforms reflect your concerns about the privacy of your information, and how do we deal with the power that comes from data? And I'll leave it at that, because those are really big questions in my area.
Thanks, Deborah. Shalja and Monica, over to you.
Yeah, maybe I can take this one. So I have, some food for thought for the audience in the sense of how can we make digital chapters or electronic commerce chapters in FTA or digital economy agreements more development friendly. And this is not just limiting it to, what can we have in the source code provision and what we can have in the cryptography provision, but more broadly, because right now the assumption is just having a digital trade chapter itself and, just free flow of data and no localization requirement is what you need, to assist governments from developing country in, making that developmental leap. But what else can we do? So that's all.
Thank you so much. Heng, over to you.
Yeah, I think that's technology move faster than institutional governance. Ranging when we face challenges like the data poisoning, cyber attacks. So, question is that how do we handle uncertainties, and also how do we need to have the foresight? Since the technology moves much faster, like generative AI, which affect everyone's life. Thank you.
Thank you, Marta. Over to you.
I think my question relates to some of the others that have been said, but in my I really want to know from the audience whether they think that that international economic law and international trade agreements should be the way to go to regulate artificial intelligence, or should we use other fora to do this? Thank you.
Fantastic. Thank you so much, all the presenters, for your wonderful insights, and thank you to the audience for your interest. And with this, we conclude the session. We're 3 minutes late. I'll take the blame for that. Thank you so much.
Thank you, Anton.
Thank you so much, Anton.
Thank you so much. Thank you, everyone.